Good morning.
Good morning, Mr. Allen.
Please, this honorable court, I represent 81 Spooner Road, LLC, in this challenge before you, challenging the legality of a Brookline zoning bylaw. Specifically, our position is that the town of Brookline's floor area ratio regulations directly violate Massachusetts General Law, Chapter 40A, Section 3. And that is because Section...
Well, let me interrupt. You don't dispute that municipalities have the right to control density, do you?
Absolutely not. They have the absolute right to control density. And I'm glad Your Honor asked that question, because this bylaw doesn't regulate density. Because in our case, and what's critical to understanding the issue in this case, which I think the land court missed respectfully, is that Brookline allows you to build the density. Brookline allows you to build the density, but once you've built the density, Brookline doesn't allow you to use it.
Well, that does have an impact on density, though.
No, respectfully, it does not, Your Honor.
What does density mean?
Density means the size of the building. You can build an attic. You can build a basement in Brookline, but you can't. In certain instances, you're then not allowed to use it. So that the critical factor that I think is the flaw in this bylaw, and it's unlike most other bylaws, and it's interesting, I looked at the bylaws cited by the town and the amicus briefs, none of them are similar to Brookline.
Has any other jurisdiction outside of Massachusetts ruled in your favor in a similar situation?
No, because I can't find a jurisdiction that has a bylaw like this.
What's different between this bylaw and in other communities?
Most other communities, Your Honor, have a bylaw that says you can build 3,000 square feet. The mistake Brookline has made is they make a distinction between habitable and uninhabitable, and they make a distinction as to what you can use and what you can't use.
Well, is the dwelling house at issue here, is that over the allowable FAR without even including any attic or basement space at all?
It's our position it's not if the contested area would be an attic. That's in a separate case that, depending on how the land court rules or how you rule, might be here later.
But that's where it started, is that right? When the
that is
building
correct. But if this bylaw, and I think that's a good example, because remember in this case, the building commissioner agreed that the contested space was an attic and issued a building permit. When you read some of the amicus briefs, not the towns, but the amicus, it's almost like the big bad developers snuck in the middle of the night and built this house illegally. The building commissioner issued a building permit. It wasn't until the house is almost finished that this issue arose. And the problem with the Brookline bylaw is it makes that distinction between habitable and uninhabitable. If the Brookline bylaw was like every other density bylaw and just said you could build 3,000 square feet or 4,000 or 15% and didn't make the distinction between habitable and uninhabitable, there'd be no question.
I'm very confused by that argument. In other words, if the bylaw said you can only build 3,000 square feet of interior space, that would be consistent with Chapter 40, Section 3?
Yes, because then I believe...
Wouldn't that be a bylaw restricting the area of a single-family residence? I thought that would be a problem.
No, because you're allowed to do density. What you're not allowed to do, and I believe that in that point your effect on density would be indirect. I mean, your effect on interior space would be indirect in line with your cases. But what they have done, Your Honor...
So is the 3,000 square feet you're talking about being the whole building?
The whole building.
Okay, so it's not just interior space.
Well, that's all interior space. There's no other part of the building other than interior space.
But you're saying the footprint of the building can be 3,000
Right.
square feet,
What-
and that's not in violation of the bylaw, you would say?
None of the general laws.
General.
Right,
general
no, that
law,
would have,
that's right, yes.
it's the same way, and one of the amicus briefs says this, and this is not what we're saying. You could regulate density simply by regulating setbacks and height, and thereby not violate the bylaw if you chose. You could regulate density by saying a percentage of lot coverage or a gross square footage. But here's the problem in Brookline. Your Honor, you could have a house in Brookline, And it had two houses, they're identical, next to each other. And in one house, the residents put a ping pong table in the basement. And that house now violates zoning. Where in the house next door, which is identical, they have nothing but cardboard boxes in the basement. That house complies. Brookline specifically allows you to build density, but not use it. And if that doesn't violate 40A Section 3, then 40A Section 3 doesn't mean anything.
So essentially, you're saying that because you can build the same size house, and it only depends on what you use some of the interior for, that's why the bylaw...
Absolutely, because the law says you can't regulate or restrict. If they're telling me I can't read a novel in my attic or build a sitting room in my attic, then they're restricting the use of my interior.
So if the purpose of the bylaw is to prevent these huge so-called McMansions from being built, it isn't having that effect because you could build a just as large a house outside. The exterior would be just as large. It just depends on what you use the inside for.
Exactly.
So I take it you're saying that the bylaw allows you to build a house, at least from the outside, they all look the same, but given this floor area requirement, once you get above a certain ratio, you could not build what we would call an attic. It would have to be a cathedral ceiling.
Right. But the real problem is the bylaw doesn't, even though it uses the term. This is a perfect example of the devil is in the details. It talks about gross floor area. Then it defines gross floor area, so you're really talking about not gross floor area, habitable floor area. If the bylaw, like most of the cities and towns and other jurisdictions, truly had gross floor area, you can build 3,000 square feet, then you don't have a problem. But they tell you can build 3,000 square feet of habitable space in Brookline. And so if you build a basement or an attic and you use your 3,000 square feet in the main floors, you can't use your basement or attic.
But you should even be able to, well, I would see.
It should be a gross. See, the problem we have here is you get in.
But you have 10 years. After 10 years, you can
Right.
You can apply to
Right.
use your attic, to read in
Which
the attic.
makes no sense, respectfully, because that doesn't
By
protect
the time your
public.
family's all grown.
Right.
you
Can't see to read.
I mean, you can't build a playroom in Brookline if the
That
problem
does have an
is
effect on density, though. I mean, if you're talking about people density,
no, because it only relates to single family. So I guess Your Honor would be correct if people decided how many children they'd have
Doesn't
based
apply
on
at
the
all to
attic to
It
basement.
doesn't apply to two-family homes? at
No,
all?
Your Honor. So, and what the key here is this general law keeps the building commissioner out of your house. Right now, we have a situation where the building commissioner has to peek in your window to see if you're using your basement illegally.
well, Mr. Allen, I should remember this, but there was a change in the attics or cellars used to be treated one way and now are treated the other. Can you just remind me what?
That's the 10-year rule.
Oh, that's the 10-year.
That we challenge. But the real challenge here, and I would say this, and it's interesting because, as you know, we had little late notice yesterday, and last night I was reading the briefs, the opposition.
So was I.
Well, we both missed the Red Sox game that wasn't memorable. But as I was reading the briefs, it struck me to what great lengths my sister and the amicus briefs went to rewrite Chapter 48, Section 3. If the legislature really wanted to say what the amicus brief said, or the town says, they could have simply said no zoning bylaw shall set a minimum size for a single-family house.
Yeah, but this doesn't. This requirement sets it's a cap. It tends to act as a cap, not a minimum.
No, I respectfully think that this law simply says.
Isn't your better argument that they're preventing you from using floors that they would otherwise allow you to build?
Absolutely. That's the strongest argument. But to do that, they're violating the general laws, which say, because if I can't use my basement or my attic, then I'm hard to imagine how that doesn't equate to restricting or regulating the interior area of a single-family home.
Well, let me say, what the land court judge concluded was that they were merely regulating the exterior and that it was just purely incidental that it impacted on the interior.
But the mistake, I respectfully suggest, the land court, was the judge did say they're regulating density with an indirect effect on the interior. There's two mistakes on that. They're not regulating density because they've allowed me to build the density. The density is there. That is the linchpin of the defense and the land court, which fails. Because to regulate density, you have to say you can't build it. The density is there.
Yeah, it's a use regulation.
Absolutely. And that's what they've done in their floor area ratio regulations. They've turned it into an illegal use regulation. Because if they were really interested in density, they wouldn't let me build it.
Yeah, you'd have to have a cathedral ceiling and no attic.
Or the like, or use a square foot. But if you have the problem they have here is, it doesn't affect density whether my children have a playroom. It doesn't affect density whether there's a ping pong table or an exercise machine in the basement. That doesn't affect density, so it's not. And the second mistake, respectfully, that the land court made was this is not indirect. Indirect is I think the term used.
But the statute,
incidental.
The statute says it says it can be subject to a reasonable regulation concerning bulk, and I'm skipping over some words, height and building coverage requirements. So you can have you have a footprint. Bulk means something different than height and footprint.
I agree with you, but I also think that language has nothing to do with this case, respectfully. That language relates to the Dover Amendment.
Your case is it's an illegal use regulation.
Exactly, because they're restricting the use of the interior. And it's not, as the town or the amicus or the land court say, incidental. It's direct. Incidental is like the Cambridge case where parking is only an incidental impact on the educational use. That's incidental. If we were talking about the setbacks or the height and saying that was illegally controlling the interior, that I would agree would only be an incidental effect of the zoning bylaw.
I'm just curious. You said that the Brookline regulation is is unique in Massachusetts, but I'm just curious. One of the amicus, the city solicitors and town council, suggests that if we rule against you in this case, it would affect many other municipalities.
That's wrong.
It would have a significant impact on many of the municipalities.
If the court entered a far-reaching decision, which is not something I'm advocating, you could, under this case, do that. But what we're simply saying is that what all you need do in this case is rule that a bylaw has to be, into the gross. You can't distinguish between interior spaces like the Brookline. That's the difference between Brookline and other bylaws. If you took a bylaw and you said you can build 10% of lot cover of your square footage or 20% of your lot area, that'd be fine. But Brookline distinguishes between habitable and non-habitable. So Brookline allows you to build density that you can't use, and other cities and towns don't do that.
If you had a bylaw that didn't make that distinction, but counted, is it gross floor area, by adding up the square footage of each floor of that would be fine.
That'd be fine.
And measuring by the exterior walls.
Right.
And that would not violate this.
We're not suggesting it would. And in fact, look how easy that would be. A building inspector could actually drive by the house or look at plans and make a determination. It's interesting, the legislature limited this to single-family homes. The building inspector can't go into your basement. He's peeping in the window. Oh, my God, is that using that basement?
I think the assessor can go in, right?
Yes, but
Tax assessor.
he can, but he can't.
And then he can tell
he's not
the building
supposed to talk to
inspector.
the building commissioner. And I think that's important to note, because look at the situation we have here that's before the court in this case. We have a very valuable home, 90% built, that's sitting empty, not because we violated any directive of the building commissioner, because we reviewed the plans with the building commissioner. He issued us a building permit. When the bylaw...
So what would you have to do to complete the building? You'd have to issue a written promise saying that I will not use the attic?
In our case, they found that the area in question, the Board of Appeals found that the area didn't even though it was the top area over the garage, it legally wasn't an attic. And so we'd have to rip that off. The building commissioner found that clearly was an attic, and as long as we didn't inhabit it, it didn't count as FAR. And I think it illustrates the problem with the bylaw.
But I mean, Brookline could, I take it from what you're saying. The ratio had to be .30, correct? I mean, they could say the ratio is .20 or .1, right?
Absolutely. But then
So
you
would have to shrink your building.
well, they couldn't do it once we started building, but Your Honor's absolutely right. But at least going in, you would know what you have to build. You wouldn't have to make this determination what is habitable and what isn't. You would have a clear understanding, and they wouldn't be regulating and restricting interior area that they have allowed you to build.
Mr. Allen, your time's up.
Thank you, Your Honors.
Good morning. May it please the Court. My name is Jennifer DePazzo, and I represent the town of Brookline in the case before you. The developer's argument in this case misses the mark. Density is not just about size. It also is about the intensity of use and the population or number of people living in a dwelling.
Well, this is a single-family home, right?
This is a single-family home.
You don't regulate how many children you can have.
No.
Okay, so you can have a whole bunch of children, maybe even a mother-in-law.
You can, absolutely, Your Honor. However, this is not a restriction on the interior area. This is simply a way to regulate by using floor area ratio, which the developer acknowledges is one tool to regulate the size, bulk, and density of single-family homes.
But what about his argument that you're permitting the building, the bulk of the building to be built, you're just restricting how some of the space can be used? Isn't that a direct regulation of the use of the interior space?
Not at all, Your Honor, because what we're talking about here is actually a bonus area.
Bonus area?
Yes. Non-habitable attic or basement space is permitted. It's not counted towards the gross floor area.
And it can be converted after 10 years.
It can be converted after 10 years. But let me give you the underlying case here, the example that was repeated time and again in Brookline and what our bylaws are trying to prevent. This is a home that right now, as it stands, 90% complete, is far too large for the lot size.
Far too large in what respect?
Yeah.
With respect to the FAR, if that space, and it was determined not by the building commissioner, but the zoning board of appeals went out and did an inspection, they didn't look at the space as to use. Is there a ping pong table up there? Can a ping pong table go up there? It's, is this an attic or not? And the reason why the town of Brookline decided to use FAR and gross floor area is to give developers options to design the interior space. You can build 3,000 square feet of habitable space on a 10,000 square foot lot in this particular zoning district. Take your 3,000 square feet, put as many bedrooms as you want, put them wherever you want, and if you want to have an attic or a basement that's not habitable, you can have an attic or a basement. Now, that leads us to the question of what is the benefit of distinguishing between non-habitable attics and basements and habitable basements. And I think that both in my brief and as well as certainly the amicus brief filed by the town council associations, basements are undergrade. They don't contain windows. They're usually not walkouts.
Yeah, we're talking about attics now.
Attics, yeah, in this case it's an attic. Attics are usually under hipped roofs or eaves. It allows a developer to decide where the habitable area is going. And if they want an attic or a basement for storage, they can use it. If they don't, they can use the entire 3,000 square feet as they wish. But one other thing, and this is very important.
But isn't this effectively a restriction on how the property is used as opposed to how it is constructed?
No, because there's no requirement to have an attic or a basement. You can use every single square foot as habitable space if you so choose. If you want to have an attic or a basement, in this case it's an attic, you can design the property so that it's an actual attic. Now, attics and the definition of habitable space at the present moment does not include space that under the building code would be defined as habitable. So right now 7 feet 3 inches is habitable space. An attic, to be not habitable, would have to be under that maximum, not have windows, not have finish, electrical outlets, heat, plumbing, and the type. That certainly affects the density and the intensity of use of a property. The other point that wasn't raised by the developer...
You know what I'm puzzled about? How is it then that the land court judge said that this was all done to regulate the exterior?
Because FAR and GFA are simply measurements. They're measurement tools. The gross floor area is measured by the several stories of the building from the exterior face of the walls in.
Right.
That gives developers options as to where to locate the floor area ratio. Where are they going to put the bedrooms? Where are they going to put the living room, the kitchen, the bathrooms, et cetera?
So if I understand you correctly, you're saying that it isn't how this attic space is used or not used. It depends on whether it has windows and how big the floor area of that particular space is?
Right, and the developer, I believe, would agree with me. When the Zoning Board of Appeals went out to inspect this property, what they found was what was basically going to be converted upon the issuance of the certificate of occupancy, converted into a master bedroom.
Well, I'm sorry, I don't quite understand Justice Bartlett's question and your answer. So you mean if the developer built a quote-unquote attic, and it had no windows, but then it was made into a bedroom, that's okay?
He could
because
not
it has no
not
windows?
make it into a bedroom at that point because it wouldn't have.
So the windows doesn't have any effect on it?
Well, it's all of the requirements of the state building code. If they were to come in and pull a permit after the certificate of occupancy was issued for an actual attic area, it could not be, under the state building code, converted into a bedroom because it wouldn't have.
Until 10 years.
Well, until 10 years, but only if it had the appropriate ventilation, floor bearing, load bearing, heat, electricity, all of those elements. So when the zoning board went out to look at this particular property, what you found was a huge area on the second floor, which was accessible by the same stairway that went to all of the other bedrooms, that had a master bath next to it, that had a picture window looking out the window, exactly measured the size of a king-size bed. The floor load, there was an architect on the
How
board.
is that a function of zoning? That's a function of the building code.
Right, but
If a person wanted to put their attic on the first floor and live up under the roof, does the zoning ordinance allow them to do that?
No, but what would happen,
Does the zoning ordinance allow them to do that?
the zoning ordinance allows them to put the space where they want.
Okay.
In this case, and
So the zoning ordinance would allow them to live under the roof and on the highest floor of the building and use the first floor of the building as storage and attic space?
only
Yes. Is there a yes or a no to that?
only if it didn't violate the FAR provision. So in other words, you couldn't have, in this case, you couldn't come
Okay,
back
so
and
if it doesn't
convert
violate
this-
the FAR provisions, a person could live on the upper floor below the roof and use the first floor as storage and attic space.
Not have any windows, if that's what defines
Yeah.
attic.
under zoning, but not under the building code.
Okay.
Okay. Second, the one point that wasn't raised by the developer and not addressed is the legislative history to the words regulate or restrict interior area. And I think it's very important to look at the legislative history because
But I read your brief on that, but don't you think that, I mean, it just struck me that the words regulate or restrict interior floor area, why is that, they seem fairly clear.
they do seem fairly clear. And when you look at the legislative history, it's clear that what was meant was to prohibit communities from establishing a minimum square footage for a single-family home. And it
Why
How
didn't
does
they
that got to
say
do with
that?
restricting the
Yeah.
interior area, though?
Because when you read the word interior area, if you go back to 1952, when the Lions Head Lake case, as was cited by the Land Court, was first decided, it was a case that upheld a zoning bylaw that required a minimum square footage of 768 feet of floor area for single-family homes.
Right.
And the Massachusetts legislature reacted to that by adding a provision in 1959 that provided that no provision of any zoning ordinance or bylaw shall be valid which requires the floor area of the living space in a single family to be greater than 768 feet.
I got that.
Okay, and then in 1972, again, the proposed language was that no zoning ordinance or bylaw shall regulate the minimum interior floor space or floor area for dwellings.
Yep.
Again,
And that does not what it says now.
right,
Right.
and
It
in
says no
19
zoning ordinance shall restrict the interior area of a family,
Right, but-
single-family home.
But the word interior areas certainly doesn't mean living spaces, living areas, where you're going to put bedrooms, how much livable space you can have. This is not setting, the town zoning bylaw does not set a minimum requirement of square footage for single-family homes, the so-called anti-snob zoning.
He doesn't
It's-
disagree with you on that, I don't think. What
He's
I thought
worried
I
about
heard was
minimums.
that they agree with you on the ability of a town to use an FAR, to have this kind of a ratio. What they're contending is improper is, once you've built this kind of a house that complies with the FAR, you prohibit them from using the full space as livable space.
But I think the land court was correct when they made a distinction that having non-habitable attics and basements serves an appropriate zoning purpose. Why exclude non-habitable attics? They're less likely to add bulks, cellars that are undergrade, attics that are under the eaves, and not necessarily.
But now that it now becomes a use restriction as opposed to a bulk, height, and building coverage requirement. You're changing the nature of the restriction, of the permissible restriction.
The zoning board and the building commissioner, they are not looking at how the space is used. They're simply looking to see whether it is an attic, as that term is defined, or a basement. Attics and basement are bonus. You can build an attic and a basement so long as they're not habitable areas, not living spaces, and it does not count towards your FAR. So it's not the use, it's what is this? Is this an attic or a basement?
Can you live there or can you not live there?
You cannot build it out and live there
You can
Until 10
you
years.
can build it. You can build it out, and you can live there after 10 years.
after 10 years. And the reason being is
You
that
would, if I could just interrupt for a second, just I think what you're saying is that you cannot live there in years 1 through 9, not because of the zoning code, but because if it's going to be livable space, you've got to meet other requirements of the building code. Is that why?
That's right. You'd have to come in and pull a permit. And what was happening in Brookline, and my brother has represented many developers in these situations, and in the trial of this underlying case, the testimony was that developers consistently brought in plans to the building department and marked huge areas, attic, basement. They finished the house under the building permit. It just so happened in this case the neighbor raised this issue and went to the zoning board of appeals. But over and over and over again, homes were built with large attics, mostly attics or basement areas. They finished, they got the certificate of occupancy. The developer came into the building department the next day, pulled a permit to finish the attic, made it into the master bedroom.
But
and then
isn't that a building inspector? Isn't that a building permit issue?
No,
not a zoning issue.
No, because that directly affects the size and bulk and density of that home on that lot, because if they
How does it affect the bulk and of the home? The home size outside is the same.
Because as my brother stated, what would happen in this case, they would have to remove that, what they're calling an attic space, and what the zoning board found to be livable space. They'd have to remove it. The house would become much smaller, and they'd have to design it differently.
But why would they
No,
have to
no,
remove
because
it
if
if they're not using it?
Just say it's a 3,000 square foot house. It's a 3,000 square foot house, whether it has an attic and 4 bedrooms, or whether it has no attic and 5 bedrooms.
They'd have to remove it because right now it exceeds the FAR, because the zoning board, and if it's upheld by the land court, we tried the underlying case a few months ago, the area is simply not an attic. So it far exceeds the FAR. It's too large right now for the lot.
Let me ask you this. Do most towns distinguish between habitable and uninhabitable space?
They don't have the exact bylaw that the town has. They use FAR in different ways. They define gross floor area differently. However, habitable space is certainly distinguished. I believe it was the case of Cameron versus DiVirgilio, which this court decided, where a community had a bylaw which didn't define gross floor area, and there was a provision where you could get a special permit to have an accessory apartment of 600 square feet gross floor area. And the zoning board eventually was upheld by this court because they found that they would exclude stairwells, they could exclude the basement area, and the apartment was entitled to the special permit because the actual habitable space was 600 square feet.
Could I ask you?
Could you address this question, because I'm still having trouble understanding? The developer says the town will deny a building permit to one applicant proposing to finish the basement or attic for use as a children's playroom. yet grant a building permit to a second applicant with identical building plans willing to forego the use of the attic or basement space. Is that statement correct?
The building department will deny a building permit.
To the person who will
Yeah.
wants to finish wants to use it as a children's playroom or a bedroom, but deny it to the second applicant with identical building plans who just says it's an uninhabitable attic or basement space. Is that right?
If it comes in within the 10 years, and it's 10, it's,
So why is that fair? Why isn't that you're going in and, as Justice Spina says, regulating the use inside of the building? It's the same outside space.
well, with the 10-year provision, it's a balancing. It's a balancing of the interests of growing.
Forget the 10-year provision. This is what the original builder wants to do.
The only way that the original builder is going to be able to come in and pull a building permit to finish that space is if they built it so that it can be habitable space. And that's exactly what happened in this situation. They called it an attic. They could come back.
Why is that permissible regulation? The size,
For the zoning.
the overall, for the zoning, the overall size of the house is the same.
It's a bonus. If you want to put in an actual attic or a basement for storage purposes and not for living space, you can do that. By not allowing,
Maybe you need to change your bylaw then and have the floor area.
if the bylaw were changed, there would not be permitted attics and basements.
That's right.
Right.
But it would be a
But
much more...
but this simply gives designers and developers options.
So if this house is built with the space that you say isn't an attic, and it didn't have windows or whatever it is that goes to define something that isn't an attic, I mean, an attic doesn't have windows, am I right about that? I don't know.
There are many factors that the zoning board took into account and are in the definition of what
Okay,
an attic
but
is.
if something meets the definition of attic, right,
Right.
and it's huge, it still counts.
No, it wouldn't count.
I mean, it wouldn't count, but I mean, you can still build it.
It wouldn't count, and you wouldn't be able to come in and convert that for 10 years.
But it's going to be there when you're driving by. There is this huge building, right?
Right. But it's an economic disincentive because no developer is going to build a huge attic, waste that valuable space, and then market a house that you can't do anything with a 2,000 square foot attic until 10 years. So it's a disincentive to developers that were trying to take advantage of this loophole in the bylaw.
Counsel, I'm going to have to stop you. Your time is up.
Thank you very much, Your Honors.